Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2019-224E and 2019-225E. Let's take roll. Present in the hearing room, we have Commissioners Caston, Powers, Belzer, and Jay Williams. Joining us virtually, we have Commissioners Thomas and Irvin. Yesterday, before we recessed for the evening, Attorney Burns raised the issue of a motion. Is there a motion?
Mr. Chairman, Richard Witt, may I be heard?
Yes, sir.
Thank you, Mr. Chairman. We did have something that has come up, and we have talked to the company's counsel this morning, and we had a request that that conversation only took place a few moments ago. So we quickly sent an email to Joanne and Hearing Officer, Ms. Wessinger Hill and David Stark, and we would respectfully request a short delay while Mr. Chairman, you and your counsel have a chance to look at our email request. And after you dispose of that, Mr. Attorney Burns does have a motion.
Yes, Your Honor. Yes, Mr. Chairman, it's just that we'd like some clarification on some rules, but we think, and along with counsel for Duke, that it's best discussed with you as if it were a bench conference, and that's the substance of the email.
All right. Well, let's stand by and see what is said about this email. We're not going to go off the record. Just stand by. All right. I think there may have been a little bit of confusion. We were still on the record, but the microphones were off. So gentlemen, here is my concern. I understand the concept of a bench conference. Usually, there are sensitive issues that need to be discussed that need to take place outside the presence of a jury or anyone attending the proceeding. I'm not necessarily sure how applicable that is for this proceeding. Can you give me a little bit more information as to why a bench conference would be necessary?
Mr. Chairman, it's John Burns for CCBA. That idea came up between council. The idea is to reach clarification on a rule interpretation without, I guess, well, we were sensitive to stating that there was anything untoward that occurred by opposing counsel when we're not necessarily sure, given some contrasting understanding of the rules, that anything untoward occurred. So, and I'm sensitive to Mr. Ellerby and Ms. Doolin and not wanting to jump up and down and say that. If there's an interpretation of the rules, that would certainly make it clear that nothing did happen. But I do think there needs to be some explanation and some understanding of the commission's understanding of the rules. And I'll also defer to my experienced local counsel on issues of local rules before your commission. That's why we've got him.
Understood. And let me say this: I respect and appreciate the sensitivity that you are treating this matter with. But we are big on transparency here, and I believe that you can state your position without being disrespectful to opposing counsel. We're just trying to get to understanding of what happened and make a determination from there. So in regards to a bench conference, I don't necessarily see the need for that here. Let's be transparent. Let everyone who's a part of this proceeding and who is tuning in get opportunity to see how the sausage is made and do the best we can at making a decision. So if you have a question, if you would raise it at this point so we can try to work through it.
Okay. I see Mr. Ellerby's got his mic on. I didn't know if he wanted to weigh in before we started that. But... Okay.
Attorney Ellerby?
Well,
Mr. Chairman, I'm was just going to weigh in on the question of whether a bench conference was appropriate, but you have ruled on that, and so I think we should move forward.
All right, sir.
Well, Mr. Chairman, thank you for your ruling. Yesterday, during the testimony of Mr. Bach, it became clear that the motion for supplemental rebuttal testimony that was made at the very beginning of yesterday's hearing was made after that testimony had been prepared, and we were questioning when that testimony was prepared. Either it was, in our view, it was either prepared prior to the motion to strike the Rachel Wilson report, or it had been prepared in consultation with counsel after Mr. Bach and others and the other witnesses had been placed under oath. And it's our understanding that in either of those circumstances, it wouldn't be proper actions by witness and counsel, because our understanding is that once a witness is on the stand, whether it be for direct or rebuttal, that communications with counsel would be improper. We spoke with Duke's counsel this morning, and they confirmed that they had been discussing that testimony during this week with their witnesses, the company witnesses. And I believe them on this, they believe that their understanding of the rule is the correct one, and that they are, once the witness stands down from the witness stand after direct, they can be contacted and communicated with prior to rebuttal. So what we have, we think, is a misunderstanding by somebody of the rules that apply before this commission as to contact with witnesses. And so I think the first matter is to get clarification of what this commission's understanding of that rule is. And I want to defer to Mr. Witt, our local practitioner, on his understanding and of the rules. So Mr. Witt, if you wouldn't mind, and then I guess we'll turn it over to the other side to discuss their point of view, if the commission accepts that.
Thank you, Attorney Burns. Mr. Chairman, it's, in my 20 plus years before the commission, we've always understood that when the chairman gives admonition to a witness as he steps down for 5 minutes or 5 hours or a couple of days, that he's under oath. And the way it's handled in circuit court, which, part of my practice is in circuit court, is when a witness is, we break for lunch at circuit court and witnesses on the stand, they're not allowed to discuss their future testimony or their past testimony with their counsel. So we assumed and have always followed the rule that when a witness steps down, they're still under oath. They can't talk to their counsel. And as Mr. Attorney Burns alluded to, if we have a misunderstanding of the rule and it's proper to do that, we certainly want to know, because we could then take advantage of that understanding. So just need a ruling from you as Mr. Chairman as to whether it's okay to consult with witnesses while they're still technically under oath and on the stand. Thank you, Mr. Chairman.
Right. Well, I mean, I think anyone who's practicing in circuit court or any trial court would agree with you, Attorney Witt, on that. I would agree with you based on what you just said, but everything has to be taken in context, and this is where I'm a little confused. Was there not an agreement to allow the Duke companies to have some level, and I can't remember exactly, I'm not reading the transcript, but some level of communication with their witness regarding Ms. Wilson's report?
The motion was made yesterday to allow surrebuttal testimony or supplemental surrebuttal testimony to allow Mr. Bach, Mr. Roberts, and the other witness, his name escapes me, is going to be the last witness, to address Ms. Wilson's testimony from, or Ms. Wilson's report from the stand, in addition to the written rebuttal testimony that has been submitted to the commission. In response, we did request that we be allowed to discuss the subject of that supplemental surrebuttal testimony with our witnesses. That was the agreement, and Mr. Ellerby agreed to that and did not object to that request we made. Our problem, though, with the entire concept was that we didn't know about this supplemental surrebuttal testimony until first thing in the morning yesterday. Made it a little difficult to cross-examine those witnesses on those subjects. But your recollection is correct that there was discussion of some agreement. There wasn't an agreement, to my knowledge, ahead of time before yesterday morning that would have allowed that to occur Monday, Tuesday, Wednesday, and Wednesday night.
Okay. Now, did someone not ask for any written testimony? Like, if there was written testimonies, please submit it to.
Yes, I did, Mr. Chairman. Yes, not
Okay.
to interrupt, but I did, and we got Mr. Box. But we understand that the other two witnesses, Mr. Roberts was already off the stand. The other two witnesses did not have prepared written testimony. Okay,
and so is the issue this prepared written testimony from Mr. Bach? It has Brian Bach's response to surrebuttal testimony. It is 3 pages. Is that the issue, that you're concerned that this happened? This testimony was given after he was already under oath?
That and any communications that occurred with the other two witnesses as well. And someone please help me with the name of the final witness.
Mr. Snyder.
I'm blanking on it. Snyder. Snyder.
Mr. Chairman.
So go ahead, Mr. I'm going to defer to my colleague.
Well, this was Ellerby was trying to speak up. Mr. Chairman, may I be heard? Maybe help get some clarity on the difference in the position of the parties that we're asking for your guidance on.
If Attorney Burns and Attorney Witt are finished, sure.
Mr. Chairman, we're not quite finished. I think Mr. Burns had asked me to weigh in as local counsel. I think the witness on the stand, subject to, actually what he said by transcript, indicated to Ms. Mixon that he had had this testimony as far back as Monday before the motion was made on Wednesday. We understand from the conversation that was held this morning that Duke's attorneys believe that it is okay to consult with any number of their witnesses when they stand down after the direct with a rebuttal to come. And so I think they've taken the position that they did speak to their witnesses and they think it's okay. So therefore, the request for clarification from Attorney Burns, if when you admonish a witness, they're still under oath, are they free to talk to their attorneys until they're finally excused? And if they are, then we've been doing it wrong, and we could then take advantage of that. So I think and the Duke attorneys are going to speak right now, but I think that they indicated they did speak to their witnesses, Mr. Bach and possibly Mr. Snyder. And we zealously avoid doing that once the witness is on the stand. We don't discuss the subject of their testimony to come or that they've just completed or coach them in any way, like circuit court. So that's the confusion. We think that they have said this morning to Attorney Burns and their counsel's on here that they did speak with their witnesses, and there's nothing wrong with that. So I think that's where we are, Your Honor.
Okay, I understand
Mr.
now.
Chairman,
So if you would give me one second,
sorry.
let me finish with Attorney Witt. So as I understand the issue or the question is whether or not a party, a lawyer, a party's counsel can speak to the witness after they're under oath at any point, whether it's during recess for lunch or break or after their direct in preparation for their rebuttal. Is that the question before us, whether or not that's proper?
Chairman Williams, that's exactly correct. That's what we're wanting a ruling on and respectfully requesting a ruling on.
All right. Okay. Understood. Attorney Mixon?
Mr. Chairman, Goodwin Thompson.
Oh, I'm sorry,
also,
Attorney Thompson.
Ms. Mixon's colleague. I just, in response to your question, and I'm representing the Coastal Conservation League and et al. In response to your question about what was the problem that we were having or the issue we want to point out, you mentioned Mr. Bach's, prepared supplemental. That in addition to that, any testimony and exhibits that were, prepared by Mr. Roberts in consultation with his counsel after he had stepped down from direct, and then Mr. Snyder, as my CC colleagues have alluded to. Just wanted to clear that up, that it wasn't just a prepared written supplemental direct by Mr. Bach that we were referring to. Thank you.
Yes.
Okay. Now I will say this. Now we got several different parties represented by several different lawyers who I think are maybe working together, but it sounds like you all have different questions. So I just want to make sure I understand the questions that are before us so we can address them appropriately. Now, the first question raised by Attorney Burns and Attorney Witt is a procedural issue or a practice, whether or not you can talk to a witness once they're under oath. That's a pretty simple question. We can get to the bottom of that. It seems Attorney Thompson has raised the issue, well, if they have talked to their lawyers, if the Duke counsel have talked to the witnesses after they're under oath, well, we think we want anything that they submitted, whether it be testimony or exhibits, to be struck from the record. That's a different question than, they're connected, but that's a different question than what Attorney Burns and Attorney Witt raised. Would you not agree with that, Attorney Thompson?
No, Your Honor, I would not. We have the same question. I just wanted to make it crystal clear that we were, in addition to Mr. Bach's prepared supplemental, we were referring to the testimony by other witnesses. We're not seeking to strike that at this time. Just to be clear, Mr. Chairman, we're awaiting guidance from the commission on what the rules say.
Then we may have a motion for that. Yes.
Yeah, and Mr. Chairman.
Well, wait a minute. You're asking the question so that you can, depending on what we determine, make a motion to strike, right?
Correct. We're trying to
right.
determine what the rules allowed and whether we have grounds to make a motion or whether what Duke has done is entirely permissible. That's exactly what we're asking for, sir.
All right. So does anyone?
And Mr. Chairman, I'm sorry, Benson for CC, but not to belabor this. I think you have framed up the questions correctly. I do think we are all in agreement that it is not permissible for an attorney to talk to the witness while they are in the middle of their direct testimony while they're on the stand. I think the specific question is, once they have come down from the stand and they are between their direct and their rebuttal, is it permissible for the attorney to talk to them then? So I think you framed that question up correctly. And then the second question, you're right, is if there's been a violation of the rules, what do we do about it? Because I think we haven't even framed it up as a motion to strike yet. It's just, what do we do if there was a problem?
All right. Let me ask you all this. How would you want me to refer to you all collectively?
The interveners, I think, is one way to do it, Your Honor, Mr. Chairman.
Okay. The
I think
interveners.
clean energy interveners could be appropriate since there are other interveners, but I'm not attached to a nickname.
I just want to be respectful. So whatever you want me to call you, that's how I will address you. If it's clean energy interveners, that's fine. It makes no difference to me. I just want to be respectful.
That's fine with us.
All right. Anyone else from the clean interveners? Clean energy interveners.
Mr. Chairman, this is Kate Mixon. Just one very small clarification on the request made yesterday after Duke made a motion to be allowed to give this supplemental testimony. The request, and I don't want to speak for Mr. Burns, but the request was made on his behalf, I guess, about whether or not, I guess, specifically requesting permission to be able to discuss this with witnesses Lucas and Olson because they were under oath, and the understanding of the clean energy interveners was that there otherwise would not be communications permitted between counsel and those witnesses.
Okay, and since you brought that up, just to let everyone know what I'm thinking in terms of what I remember, I thought there was some level of agreement that the parties would discuss the SIR rebuttal. The discussion would be limited to that SIR rebuttal.
Mr. Chairman, Richard Witt, may I be heard?
Yes, sir.
The problem is, Mr. Chairman, it was from that point forward that we all understood that we could now, as Mr. Attorney Burns specifically asked, as Ms. Mixon just said, can we talk to our witnesses because we thought rules in effect, but that was going forward. This is actions that happened before your ruling, Mr. Chairman, that we're concerned about.
Okay. All right. Is okay. Is that everything from the clean energy interveners?
Yes, Mr. Chair.
All right. Duke companies.
Mr. Chairman, Frank Ellerby for the Duke companies. Appreciate the opportunity to respond to the issues that have been raised, and appreciate them contacting us this morning to discuss it. Our understanding, and my understanding, Mr. Witt mentioned his years of practice before the commission. I think my first involvement in cases at the commission was in 1984. And I absolutely agree, and the companies agree, that when a witness is on the witness stand testifying and there is a break before that witness's testimony is fully completed, lunch break or an overnight break, it is inappropriate for counsel to have any conversation with that witness about the substance of the witness's testimony, and we have absolutely scrupulously followed that rule in this case and in other cases. What is being raised is to me a completely new idea, which is that where you have a witness who is providing a direct testimony, and then later in the case rebuttal testimony, whether the company's lawyers cannot have contact and discussion with that witness to help us with cross-examination and to prepare for the rebuttal testimony. And we believe the rules absolutely do allow that. And Mr. Chairman, we have looked at the commission's rules since this issue, and we they didn't tell us exactly last night what they were concerned about, but we put 2 and 2 together, and we started scrambling through the books to see what there was out there. And we looked at this commission's rules, the rules of civil procedure, the rules of evidence. We did research of case law, and what we find no support for the proposition that they, I guess, are arguing should be the rule as they portrayed it, that the prohibition on contact extends beyond that witness coming down from the witness stand and prevents us from having a conversation for the remainder of the case. And there's Supreme Court cases, Mr. Chairman, U.S. Supreme Court cases focusing on whether a restriction imposed by a judge on contact while the witness is still on the stand violates the criminal defendant's Sixth Amendment right to counsel. And different cases come out different ways. There's been a lot of litigation on that issue. And that's a group of cases that all involve a presiding officer instructing a witness while he's still on the witness stand during a lunch break or during an overnight break not to have contact with his clients. There is a 11th Circuit case, I think it's 11th Circuit from 1980, I can circulate it, that held that a instruction from a judge in a federal court case that the witness couldn't have contact with his lawyer during breaks while the person is still testifying, not talking about rebuttal testimony, that violated the client's constitutional right to effective assistance of counsel. That court found that there was a constitutional right, even in civil cases, to effective assistance. So the authority that we find out there absolutely doesn't support the idea that the rule would prevent us from having contact with folks between the full completion of their direct testimony and their resuming the witness stand for rebuttal. That has been my understanding of practice at the commission. That's what we followed. I tried to sort of rack in my brain this morning and went back to the last DEP rate case, and we put up a witness, an accounting witness, early in the case, one of our first panel, and then we recalled her at the end of the case to respond to certain issues. She had been in the hearing room, Mr. Chairman, the entire time of the rate case hearing, advising us, consulting with us, helping us understand the case. And then we recalled her to testify about those things that we had been talking to her about. That nothing hidden by us, nothing surreptitious about it. Mr. Witt mentioned practice in circuit court. I also racked my brain to remember a plaintiff's case that I tried with a bunch of other lawyers in the 90s that lasted 3 weeks, and we put our client up at the beginning of the case to lay out the case. We consulted him. We absolutely needed to consult with that person throughout the course of the trial, and then we called him back up on rebuttal. And nobody raised an issue about it. In my mind, it's absolutely permitted and absolutely necessary for the party to get a fair hearing. These are, as y'all are well aware, these are complicated issues, and we need, in order to present the case effectively, we need to be able to to have contact with these folks during the course of maybe 10-day case. So we think it's the right rule. It's in the public interest. There's absolutely nothing nefarious. All of the cases, Mr. Chairman, that talk about the concerns about having contact focus on coaching a witness while he's testifying and interfering with a party's ability to do effective cross-examination. Well, that's not implicated when you're talking about the intervening time between direct examination and rebuttal. So we don't think there's any rule that says we can't have that contact. There is no rule. the practice at the commission, in my experience, is not consistent with the clean energy interveners view, or their suggestion of what their view is, and we think that they could have asked the chair, and I guess they didn't. They thought they had an understanding of it. It was different from ours. That's unfortunate, but it is not something that I don't know what we can do about it at this point. I think that's well-intentioned efforts on both sides. I'm not being critical of anybody. I'm certainly not being critical of the way that the clean energy interveners have raised the issue with the commission, but we don't believe there has been any violation of the rule, and we think that the lawyers, the Duke Energy legal team has behaved ethically and properly, and so we don't believe there's any basis for a finding that there was any violation of the rules. Thank you, Mr. Chairman.
All right. Any response from the clean energy interveners?
Yes, Mr. Chairman, Richard Witt, and I'm sure that Ms. Mixon and Ms. A. Goodwin Thompson would also want to be heard, and possibly Attorney Burns. But to start it off, Mr. Chairman, everybody knows that there is a complete difference between the rights and benefits that are accrued to a criminal attorney as opposed to in civil court. Of course, they're going to have protections maybe, but I think going back to, Mr. Ellerby goes back to 84. I only go back to 1991 before this commission and in circuit court. The judge, or in this case, the chairman sitting as the judge, has great and wide discretion on how to run his or her courtroom. Your admonition to the witness that you always give that, hey, remember you're still under oath, is meaningless if there's no restriction because they're still under oath because they haven't completed their testimony. And I believe the discretion that the Supreme Court and the Court of Appeals would give a judge or a chairman of a commission to run his or her courtroom is greatly going to outweigh anything that would be given to a criminal defendant, which we all respect and understand. So we thank Your Honor, Mr. Chairman, that you control the commission room just like a courtroom, and you have the complete discretion to say, hey, you're still under oath. And we have never, prior to this, had the practice that we could talk to witnesses between testimony. Thank you, Mr. Chairman, for letting me be heard, and the other attorneys may want to speak.
Mr. Chairman, this is John Burns for CCBA. May I be heard without testing the patience of the commission?
Yeah, sure. Go right ahead.
All right.
I'm researching or reading,
okay,
reading the law.
Thank you. Briefly speaking, I just wanted to point out two things. You mentioned in earlier colloquy that there had been an agreement or a request by CCBA and the other clean energy interveners to speak with our own witnesses, and you are correct. That request was made on the limited subject of the supplemental rebuttal that was provided by Duke Energy. We did not and do not and have admonished our witnesses that we cannot talk about anything other than that. And that was our request. That was granted. And I would point out that Mr. Ellerby agreed to that as if that was something new. If in fact it was the understanding of the Duke parties that it was perfectly fine to speak with witnesses when they come down from the stand before they go back up for rebuttal, then I'm not sure there was any concession there at all. And I don't know why the question wasn't raised. Well, you can do that anytime you want, Mr. Burns. Why are you asking for this relief? So I'd point out that inconsistency in the argument. So that's our position at this point, and we do seek the ruling of the chair. And if in fact there was any violation of the rules, then we can talk about what to do after that. But I'll defer now to Ms. Mixon to address the other clean energy interveners position.
Thank you, Mr. Chairman. I was just going to point to one other South Carolina rule that I would argue would be more applicable to this circumstance than the Sixth Amendment cases that Mr. Ellerby cited. And under Rule 30J, South Carolina Rules of Civil Procedure, which does regard conduct during depositions, which is somewhat distinguishable here. However, it does say that counsel and a witness shall not engage in private, off-the-record conferences during depositions or during breaks or recesses regarding the substance of the testimony at the deposition, except for the purpose of deciding whether to assert a privilege or to make an objection or to move for a protective order. And given that that is in a rule of civil procedure, I would just argue that that is more applicable in guiding what is appropriate conduct here.
Okay. Anything else from the clean energy interveners? So, Attorney Mixon, I think you were the only lawyer on the clean energy intervener side that mentioned a rule, SC Civil Procedure, Rule of Civil Procedure 30J. Anyone else have any cases to cite or rules to cite on the clean energy intervener side?
Not at this time, Your Honor, not for me.
All right. And Duke Companies, would you like to give me the cite to those cases that you mentioned during your presentation?
Mr. Chairman, it was the Fifth Circuit, even closer. 609 Fed 2nd 1101 is the cite, 1980 case, and that was the civil case that I cited. It discusses and draws from the Sixth Amendment cases in the criminal context. And Mr. Chairman, I'd also like to respond to Ms. Mixon's argument based on Rule 30J.
All right.
Rule 30J is controls conduct between lawyers and witnesses during a deposition. It applies the rule in depositions that applies to testimony at trial, as in when you take the witness stand or sit down for the deposition, until the deposition is concluded, your contact between the lawyer and the witness is limited. And it's, in our view, it's completely consistent with our understanding of the rules that apply in this commission. And that is that while our witness is on the witness stand testifying, we can't have contact with our witness, and we don't do that. And we follow that rule. But when the person comes down from the witness stand and is no longer subject to cross-examination, that restriction on communication is ended. Now, one other thing while I'm on the point, we did not have an admonition from the chair that instructed our witnesses not to have any contact with your lawyers. To say that somebody's under oath for is one thing. To say, as happens in many cases, you're still testifying, you can't talk to your lawyers. Those are two different things, Mr. Chairman. And we did not understand. We heard you say to folks that they're still under oath. We didn't understand that meant that after their direct testimony and cross and redirect and commissioner questions, all that was concluded, that we couldn't have any contact, and there wasn't any admonition. Now, somebody could have asked the chair to provide an admonition if once it was clear that there was testimony that was going to be direct and separated from rebuttal, and once that was clear, parties could have asked the chair to issue a ruling on this issue in advance, that no contact during that period of time. We would have resisted that request for the reasons I explained a few minutes ago, that we need, in order to effectively present our case, we need to be able to talk to folks about what's going on in the hearing. We think that, as I said, we think that promotes a full presentation, and we think that rule ought to apply to everybody. Obviously, Mr. Chairman, we regret that they were not having the same contact with their folks that we do, but that's not our issue, and we did not violate any rules, and 30J absolutely doesn't apply. For 30J to apply, it would be, you can't have any, to make it analogous, you can't have any contact between the deposition and the trial testimony, because direct and rebuttal is a little bit analogous to that. So 30J doesn't apply here, Mr. Chairman. Thank you.
Mr. Chairman, may I briefly respond to that?
Yes.
I think there's a distinction that needs to be kept in mind here between a witness who is excused from the stand after the conclusion of his testimony and then recalled later, and someone who is still gives direct testimony and then is coming back for rebuttal and has not been excused, as none of these witnesses have been. I think there's also a distinction to be brought with the practice before this commission of submitting all the testimony at once in writing. The commission has the rebuttal testimony in front of it. That witness is definitely coming back and has already come back in a sense, and is still under oath, and that admonition should apply. At least that's our understanding of the rule. And I'll now stop my argument. I appreciate your time.
All right, Attorney Ellaby, I agree that I did not tell any witness not to communicate with their attorney between direct and rebuttal, but I did say that they're still under oath, and maybe this was a mistake on my part. I believe that implies that your testimony is ongoing, and because your testimony is ongoing, you should not have contact with your attorney or anyone about your testimony. Is that not a fair implication? To remind the witness that they're still under oath?
Well, Mr. Chairman, that is certainly not our understanding of what it is typical in practice before the commission that when somebody gets back up on rebuttal or in response, if they were sworn before, the chairman will say, remember, you're still under oath. That's my understanding of what that means. The admonitions that I have heard from previous chairs over the years, when it was the intent of the chair to tell the witness and counsel that you can't have contact, it was when a direct examination or cross-examination was interrupted by a break, and the chair wanted to make sure everything was clear, that there couldn't be any contact. So we did not interpret your reference to being under oath in that way, and so that's something else that.
Well, so if that's the case, and you brought up your interpretation of Rule 30J in that it exists so that the lawyer does not have contact with the witness during the deposition because the deposition is ongoing, similarly to a lawyer not having contact with a witness in circuit court while testimony is ongoing. Did you not say that?
Yes, did.
Okay. So is testimony not ongoing if the witness is sworn for direct, steps off the stand, is reminded that they're still under oath because they have to come back for rebuttal? Is that not ongoing testimony?
No, that's not ongoing testimony in the same way that Rule 30J is addressing it, or an admonition to a witness who's still testifying and is still subject to cross-examination. That the rebuttal testimony, yes, is pre-filed, but until we recall the witness for rebuttal, it's not part of the record, and we could withdraw the rebuttal testimony. So it's not ongoing testimony. In a trial, you don't know when, in a trial setting, you don't know whether you're going to call people in rebuttal or what you're going to call them to talk about. And you would have to have access to your client and to your witnesses during the course of the trial. If you think about that, Mr. Chairman, you consider, in a normal trial, you would have to be able to have contact with people to decide whether you're going to call them for rebuttal. So, to me, a rule that you couldn't have any contact, if you think about it in a trial setting in circuit court or federal court, that would be completely unworkable. That a lawyer couldn't have any contact with witnesses after they've testified to decide whether because you might call them in rebuttal, therefore you can't have any conversations with them. That just I can't see how that could possibly work. And those are the rules that we're supposed to be applying here.
And so your understanding is that in your past experience with the commission, and just side note, I hear that said a lot, but if you look around, you can tell this is not the same commission that it once was. Hopefully everyone can concede on that point. It's a new commission. But just to hear your argument out, it sounds like you're saying that if a chair specifically told you or your witness not to have contact with the lawyer, you comply. But if those magic words are not used, then you feel free to talk with your witness.
Let me modify that, Mr. Chairman. If the witness is still testifying, if the direct examination has concluded and there's a lunch break and cross-examination hasn't taken place, we do not, whether there's an admonition or not, we do not have any contact with that witness. And we have followed that rule carefully in this case and in other cases. So and that is what we understand the rule to be. I simply mentioned that in my experience, that's the type of when the admonition has been given to witnesses, when their direct examination or perhaps their rebuttal examination was interrupted before they stepped down from the witness stand. That's when I've heard the admonition from the chair not to have contact with the lawyers.
Right. Well, that's fair. But it seems like what you're saying is the rule is not a standing rule. It's not a consistent rule. It's one that if the chair says between direct and rebuttal, if the chair says don't have contact with your witness, then you wouldn't. What I just find that to be a little inconsistent, though. It doesn't provide for consistent practice before the commission if the rule applies when the magic words are used, like spelled out completely, as compared to just reminding the witness that they're under oath.
Well, Mr. Chairman, and there aren't, that's one of the things that we found. There aren't clear rules on this. There's nothing in the rules of evidence that specifically addresses this issue. Nothing in the commission's written rules that specifically address this issue. The case law all involves a presiding officer, usually a judge, issuing instructions during a trial about limiting contact. That's where the case law is. That's what we looked at for guidance, and that has taken place while the witness is still on the stand testifying. We found nothing that says that person can't confer with his lawyer because he may be testifying on rebuttal 2 weeks later in a trial. And we absolutely, Mr. Chairman, I think you know this, if a ruling had been, or clarification or instructions had been requested and you had told us that we should not have any contact with our witnesses between direct and rebuttal, as I said, we would have resisted that, or at least we would have tried to persuade you to do otherwise, but we agreed that, we would have followed your instructions on that, absolutely. But we did not understand, and I don't think it is a reasonable interpretation to say that because the people remain under oath, that that's the same thing as not having any contact with the lawyers. under the circumstances that I've described several times.
All right. Anything else from the parties?
Mr. Chairman,
Commissioner Urban.
one thing that we may have learned from this experience is that going forward, it might be best to have the witness summarize their direct testimony and their rebuttal testimony or surrebuttal testimony while they're on the stand. That it seems like that's been our practice in the past. I'm not sure why we split it up this time, but maybe that's the lesson learned. But the observation that I'd like to make is that all the attorneys are correct. The commission has no rule that covers this particular question. So my thought is that there's nothing before the court to to rule upon until and unless a party moves to strike the testimony. And I believe if the party moves to strike the testimony, then they'll have the burden of showing that they've been prejudiced in some way. Absent of showing a prejudice, then testimony should be considered. But as it stands now, there's nothing before you to rule upon, really. And if an attorney thinks that another attorney has violated an ethical provision of the Code of Professional Responsibility, that's entirely another matter. But we don't rule on ethical issues. That's a matter for another venue. And as we all know, if an attorney has a reasonable belief to think that opposing counsel did violate an ethical violation, they have a duty to report that to the appropriate authority. But any ethical issues are not properly before us for ruling. If a party, however, feels they've been prejudiced in some way by this conduct, the proper motion is to strike the testimony in question, and then the chair can make a ruling. Thank you, sir.
All right.
Mr. Chairman, Ben Snowden for CCBA. If I might have a moment just to respond to Commissioner Urban's concern.
Okay.
And I absolutely respect and understand Commissioner Urban's view that this commission is not, as they say, in the business of issuing advisory opinions, and that no motion to strike has been brought. However, in addition to understanding, well, what we're seeking here in part is simply clarification of what the rules are going forward, because that is going to dictate how the interveners will also be, whether we will be contacting, our witnesses to discuss the substance of their testimony. We certainly don't. So we would like to understand what the ground rules are so that we can all be operating on the same page. Thank you.
All right. We're in recess until 10:15. We're back at the Public Service Commission of South Carolina's hearing in docket numbers 2019-224E and 2019-225E. Let's take roll. Present in the hearing room, we have Commissioners Caston, Powers, Belzer, and Jay Williams. Present virtually, we have Commissioners Irvin and Thomas. So before the commission was a decision regarding or request to clarify or give instructions as to whether or not a witness could talk to their lawyer about their testimony once they had stepped down off the stand between rebuttal and, between direct and rebuttal. I received the arguments, the cases were reviewed, and I must say, I'm a little surprised that this was even at issue because in my practice, it's pretty basic that once a witness is sworn in, that they should not discuss their testimony with anyone, let alone their lawyer, until their testimony is complete and excused. That witness being excused. And I believe in accountability. So if me saying or reminding the witness that they were under oath or they're still on the oath did not send that message, then I'll take responsibility for that. But please know that as long as I'm chairman, the rule is when a witness is sworn in, they can't talk about their testimony with anyone until the testimony, all of their testimony is complete and they are excused. And if I need to say that with every witness, then I'll just have to say that to make sure that's clear. So that's my ruling as to that question. Is there anything else?
Chairman Williams, we have a motion.
What's your motion?
Thank you. And we, and by this I mean CCL et al., as well as CCBA. We think that the prejudice to our clients from this is clear. Duke's attorneys have been communicating with their witnesses while they were under oath, which gave them the benefit of additional time and preparation that neither we nor our witnesses have had. And frankly, it's difficult for us to kind of think about what an appropriate remedy may be, because this does not just affect the witnesses that are presenting additional testimony. It appears to be all of Duke's witnesses who appeared on direct and will be coming back for rebuttal. But we would like to request the following and believe that it would be a fair remedy moving forward. First, given that the additional testimony from witnesses Roberts and Bach has already been given on the stand and was subject to cross-examination and questions from the commission, we understand that it would be difficult to strike all of that related testimony from the record. But to relieve the prejudice as associated with that improper testimony, we request that we still be permitted to provide additional testimony on the stand from witnesses Rachel Wilson and CCBA witnesses Arnie Olson and Kevin Lucas related to the supplemental testimony from Roberts and Bach, and that CCBA counsel be allowed to communicate with Olson and Lucas regarding that response to the supplemental testimony. Second, on a go-forward basis, we would move that Duke not be permitted to present their additional testimony from Glenn Snyder, for which we have not received any materials from Duke, so that we or our witnesses could prepare a response, and that Duke be admonished not to speak to any of their witnesses that are still under oath moving forward.
All right, your first request is granted. The second request, I'm going to need you to flesh that out for me a little bit. When you say additional testimony from Mr. Snyder, are you referencing all of his rebuttal testimony or just a certain part?
Sorry, I apologize, Chairman Williams. I was referring to the additional testimony from Glenn Snyder that Duke was planning to have him present from the stand on Rachel Wilson's synapse report.
Okay, and you're making that request because
Again, Mr. Chairman, we have not received any materials from Duke about what the substance of that testimony may be. We have had no opportunity to respond to it. We've had no opportunity to speak to our witnesses about what that supplemental testimony may be. And again, it appears that that testimony was prepared by Duke after witness Snyder was under oath, and so we believe that that was improper.
Okay. So it's really more so you think that his testimony you think they talked to him. You think Duke counsel talked to Mr. Snyder about his testimony?
Yes, Mr. Chairman.
Mr. Chairman, I'd
Okay.
like to be heard on that point when you're ready.
Yes, sir. Yes, please.
And Mr. Breitschwert has been working with Mr. Snyder. Just to give you a little bit of background or reminder, we argued the motion to strike on Monday, and you denied our motion to strike on Wednesday or Thursday. You agreed to allow us to provide limited response to the materials that were the subject of our motion to strike. We have talked to the witnesses. We necessarily had to talk to the witnesses this week. It was absolutely unavoidable to talk to them to decide what they were going to work with them on what they would say in responding to that. I think that so that has happened. That's what Ms. Mixon is asking, that Mr. Snyder not be allowed to provide that supplemental testimony that we asked for permission to submit in response to the materials on the motion to strike. I would suggest the alternative approach would be to allow, if there's some response to what Mr. Snyder has to say, we certainly agree that they could, Ms. Wilson could retake the stand and respond to after Snyder testifies. But we think it's important for y'all to hear what he has to say about the Synapse study and the all-source procurement things that were the subject of our motion to strike. So I'd offer an alternative remedy with respect to Ms. Mixon's request. Thank you.
Mr. Chairman, may I respond to that briefly?
Yes, ma'am.
Mr. Chairman, you ruled on that motion to strike on Monday. And what appears happened is that after that, Duke counsel improperly communicated with witnesses Roberts, Bach, and Snyder to prepare this supplemental testimony between Monday, but then only asked the commission for permission to present that testimony on Wednesday. At no point during that period from Monday to Wednesday did we know that Duke was communicating with those witnesses, nor did the commission know. And for that reason, that we do not believe that that additional testimony from Mr. Snyder should be allowed into the record. We did not ask for the testimony of Roberts and Bach to be struck from the record, simply because, again, it already had questions from cross-examination and many commissioner questions. We would have to go back into the record to determine, what testimony related to that additional supplemental testimony and what didn't, and recognize that would be very challenging to do. And so that is the reason that we asked just to be able to respond to it. But we do not think it's appropriate that this additional testimony from Mr. Snyder be allowed in on a go-forward basis. And again, we have not received any materials from Duke about what that testimony might even be.
Well, Attorney Mixon, let me ask you this. You've put together a theory of what you believe may have happened. if your theory proves incorrect, and Mr. Snyder did not talk with his lawyers until after the motion was made or the request was made for the opportunity to prepare supplemental testimony, will that change your motion?
I perhaps, Mr. Chairman, but I mean, I believe Mr. Ellerby just admitted that they were in communication with Mr. Snyder prior to Wednesday.
Mr. Ellerby, is that true?
Mr. Chairman, I think I'm going to have to ask one of my colleagues to address that question. Maybe I didn't have any contact, but I would not have been the person that would have had contact with Mr. Snyder on that subject. So I can't answer that.
Ms. Mixon, and Mr. Chairman, if you don't mind, hi, it's Rebecca Doolin. Is the question the extent to which there was contact with Mr. Snyder beginning on Wednesday? I'm sorry, I want to make sure I understood.
I believe so. Whether or not Duke counsel spoke to Mr. Snyder about his supplemental testimony before Wednesday.
Yes, and Mr. Breichwart is with us, and he can clarify further. But under the understanding of the rules that Mr. Ellerby has described earlier, certainly we were in contact with our witnesses after they left, after they completed their direct case, and before they began rebuttal, which Mr. Snyder has not yet begun. Mr. Breichwart, please correct me if I have a misunderstanding.
That's right, Ms. Doolin. To the best of my recollection, the chairman denied our motion to strike at around 10:15 on Monday. Mr. Snyder went on the stand at about 10:20 and then went off the stand later in the afternoon. And I had, as Mr. Ellerby said, and being a lawyer who practices in North Carolina, had adhered to the directives that Mr. Ellerby had set forward in the guidance. But my understanding of the rules, no communication with Mr. Snyder while he was on the stand. There has been some limited discussion of the need for surrebuttal testimony from the stand by Mr. Snyder, similar to Mr. Roberts, in oral form. We don't plan to introduce any exhibits, but the substance of that testimony would be similar to Mr. Roberts in that we would articulate the company's views that the synapse report is flawed from a modeling standpoint, which is the area of Mr. Snyder's expertise. So myself, not being an expert on modeling, needed to confer with Mr. Snyder and his team to understand what questions to ask and to help prepare to present that testimony to the commission. So those limited discussions have occurred. There's no supplemental testimony that's been developed. There's no pre-filed surrebuttal that would be introduced. There's no planned exhibits, at least at this point, that I'm aware of from Mr. Snyder and his team that we would plan to introduce and to help inform the commission on these issues.
Understood, sir. And those conversations took place on Monday?
To the best of my recollection, yes, sir, after Mr. Snyder left the stand.
Understood. All right, Attorney Mixon, your second request is granted. Remind me the third.
We requested the Duke be admonished not to speak to any of their witnesses that are still under oath and have not yet presented their rebuttal testimony.
Okay, well, I appreciate that, but that rule applies to everyone, and hopefully my opening remarks make that clear that witnesses should not discuss their testimony with anyone while they are under oath, while their testimony is not complete, and until they are excused. All right. Is there anything else? All right. Please call the next witness.
Good morning, Mr. Chairman. The companies would call Mr. Mark Oliver to the witness stand.
Good morning.
Good morning, Mr. Oliver. He hasn't been sworn in yet, Mr. Chairman.
All right. Good morning, Mr. Oliver.
Good morning.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Thank you. Mr. Oliver, would you please state your name for the record?
My name is Mark Oliver.
And you've not appeared in this case to this point, is that correct?
That's correct.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Corporation as Vice President of Integrated System Planning.
Thank you. Did you prepare or cause to be prepared 12 pages of rebuttal testimony that were pre-filed with the commission in this proceeding?
Yes.
If I asked you the same questions that were contained within your pre-filed rebuttal testimony this morning, would your answers be the same?
Yes.
Mr. Chairman, at this time, I would ask that Mr. Oliver's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Oliver's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Oliver, did you also prepare or cause to be prepared 2 exhibits that were attached to your pre-filed rebuttal testimony?
Yes.
Do you have any changes to those exhibits at this time?
No.
Mr. Chairman, I would ask that Mr. Oliver's pre-filed rebuttal exhibits be entered into the record as the next hearing exhibit.
Mr. Oliver's pre-filed rebuttal exhibits will be marked as a composite exhibit and entered into the record as hearing exhibit 37. Thank you.
Thank you. Mr. Oliver, what are your responsibilities as Vice President, Integrated System Planning?
I lead the Integrated System Planning Group, which includes integrated resource planning, as well as integrated system and operations planning. I'm licensed as a professional engineer in North Carolina, and I've been employed by Duke Energy or predecessor companies for 28 years, which includes experience in unit commitment and dispatch optimization, power trading analytics, fuel and operations planning, and nuclear systems engineering.
Thank you. Would you please describe the company's Integrated System and Operations Planning, or ISOP, initiative?
Yes. ISOP is a planning framework that optimizes capacity and energy resource investments across generation, transmission, distribution, and customer solutions. The ISOP team is developing an integrated planning framework for the companies to coordinate distribution and transmission planning with generation planning that is conducted through the IRP process. The companies are planning to formally include the ISOP framework in the 2022 IRPs and shared about development of ISOP in the 2018, 2019, and 2020 IRPs.
And how are you and the companies engaging stakeholders in this ISOP process?
The companies have taken a collaborative approach to information sharing in parallel with the development process and launched a stakeholder engagement effort beginning in 2019, including a series of stakeholder webinars and workshops to inform the development of ISOP modeling tools and analytical process, reach a common understanding of key issues, and assess achievable beneficial outcomes for our customers and other stakeholders through information sharing and constructive discussions. The companies plan to continue the stakeholder engagement effort until the basic elements of the ISOP planning framework are incorporated in the company's 2022 IRPs. A final report from ICF on the 4 ISOP stakeholder engagement sessions, which were labeled as ICF stakeholder report, is attached to Oliver Rebuttal Exhibit 1.
Thank you. How do you respond to Witness Fitch's recommendation that the Commission should direct the companies to continue development of ISOP in line with best practices?
No such directive is needed from the Commission since the companies are already developing ISOP for the 2022 IRPs and doing so in line with best practices. The ISOP team at Duke Energy participated in Smart Electric Power Alliance's development of the report referenced by Mr. Fitch in order to ensure that the companies are in line with industry best practices on integrated distribution planning. And I've included that as Oliver Rebuttal Exhibit 2.
Thank you. And what else are the companies or the ISOP team doing to remain in line with best practices?
The ISOP team has also supported the National Association of Regulatory Utility Commissioners and the National Association of State Energy Officials Task Force on their comprehensive energy planning effort as a utility planner / subject matter expert, and has consistently engaged with related Electric Power Research Institute programs and has taken the initiative to exchange information with a number of other utilities embarking on this type of integration.
Mr. Fitch proposed in his direct testimony that the company should avoid moving forward with generation, distribution, or transmission investments that could be deferred or displaced by distributed energy resources if analytical capabilities were already in place. How do you respond to that?
I do not believe Witness Fitch's recommendation is prudent or practical, nor is it necessary. Placing a requirement on the companies to perform extensive, complex analysis on these existing projects could hinder the company's ability to complete them in a timely manner. Further, the companies are developing a screening process to minimize the potential for missed opportunities, and preliminary results indicate very few projects are close enough to economic viability to warrant detailed evaluation or that are more economic than traditional solutions. In light of the very modest prospects for non-traditional solutions over the next 3 to 5 years, there should be sufficient opportunity for regulatory vetting of new modeling processes and results before material levels of ISOP-related project investments are brought forward.
Do the companies already have substantial distributed energy resources on their systems?
Yes, there is a significant qualifying facility energy on the grid already serving the company's customers in the Carolinas. As of February 28th, 2021, over 3,000 megawatts of installed solar has been interconnected to the DEP system and is injecting energy as weather conditions permit, and over 1,140 megawatts of additional installed solar is interconnected and injecting into the DEC system. According to the Institute Association website, the Carolinas are among national leaders in installed solar, with South Carolina ranked 12th and North Carolina ranked 3rd nationally. These facts illustrate that the companies have been and continue to support rapid development of DERs.
Thank you, Mr. Oliver. You cut out on my audio for just a second. You referred to, is it correct, the Solar Energy Industry Association?
That's correct.
Thank you. And finally, how do the companies plan to engage the Commission and stakeholders as ISOP continues to develop?
The companies will continue to provide ISOP updates to the Commission in future IRP filings and would support any allowable ex parte briefings the Commission deems appropriate for learning more about the status of ISOP. As mentioned previously in my testimony, the companies have undertaken significant stakeholder engagement efforts on ISOP and provide access to many relevant materials on their online ISOP portal. In keeping with the intended spirit of transparency and collaboration, the companies welcome any opportunity to address outstanding questions to the extent that the Commission deems appropriate and helpful. Thank you.
Thank you, Mr. Oliver. Thank you, Mr. Chairman. And Mr. Oliver is available for questions from Council and the Commission.
All right, sir. Carolina's Clean Energy Business Association.
Ben Snowden for CCMA. We do not have any questions for Mr. Oliver. Thank you.
South Carolina Coastal Conservation League et al.
Kate Mixon for CC et al. We have no questions for Mr. Oliver.
Johnson Development Associates.
Mr. Chairman, Court Walsh, no questions.
Vote Solar.
Taylor Spear, Vote Solar, permission to proceed.
Yes, sir.
Good morning, Mr. Oliver. My name is Taylor Spear. I'm appearing from Greenville in Turner Paget's office. How are you doing this morning?
I'm well. I hope you are.
I'm well, thank you, and I'm delighted for the opportunity to speak to you. I'm going to go through some things that I'd like to address with you, and I'll just ask you generally now. What's the organizational structure behind the development of the company's integrated resource plans? Who do you report to? I understand that Mr. Schneider says that it's Swati Dotson. Is that correct?
The name is actually Swati Daji, D-A-J-I.
Okay.
That was a fairly recent organizational change.
Okay. How is the integrated resource plan position to upper management, as Mr. Snyder has already told the commission has happened.
Could you clarify the question in terms of, is your question related to information that upper management receives prior to the filing of the IRP, or?
That's a fine clarification. Yes, sir. Thank you.
Okay, thank you. Yes, so we did brief the SMC prior to filing the IRP to provide an overview of the approach and results that we had at that point in time.
What is the SMC?
Senior Management Committee. Sorry about that.
That's okay. Does the Senior Management Committee have any oversight over the companies addressing climate change?
I would say in broad sense, yes, they, I'm sure would have been involved with developing the climate goals that were set forth in 2019 and prior goals.
I'll ask you a more specific question, and this comes from hearing Exhibit 5, which is the company's 2050 climate report that was published in April 2020. If I need to pull that up for you to reference, happy to do that, but I think that I'm able to get to the questioning without that. Do the 6 board committees referenced in that document have any oversight of the company's integrated resource planning? And I'm going to go through them to make it easier for you. So one of them is corporate governance. Does the corporate governance board committee have any oversight over the company's integrated resource planning?
I'm sorry, I'm not familiar with the direct involvement of the board in the IRP.
Okay, so here's what I'll do. I'll pull up the hearing exhibit for your reference, and we will probably move this quite quickly if you don't know the answers, and that's quite fine.
Okay, thank you.
I'll be showing the witness what has been previously marked as hearing exhibit 5, and I'll be referring the witness to page 9 if the commissioners and council would like to follow along. Mr. Schneider, do you see my page, which is the company's 2020 climate report?
I do. Just for the record, it's Mr. Oliver.
I'm sorry. I did not mean to refer to you incorrectly.
That's fine. I've been called worse. Thank you.
Okay. Yes, sir. I'm going to move to page 9. Okay. I went through this with Mr. Schneider. I'm sure you remember, but we essentially established there that under the company's 2050 climate report that these 6 board committees have some connection with the company's steps to address climate change. So here's the question to you. Can you tell the commission whether or not any of these committees reviewed the integrated resource plans proposed by the companies in this proceeding prior to them being proposed?
I don't know specifically, but to the best of my knowledge, that there was not a presentation to the board prior to the IRP filing on specific results and direction of the IRP.
I assume that there was a presentation in some fashion to your superior, correct?
Yes, in preparing for the SMC presentation that I referenced earlier, Senior Management Committee.
Okay. Well, the 6 board committees that I just showed you, are any of them, is there any crossover between them and the Senior Management Committee?
Not to my knowledge, but I just don't know the answer to that question. I'm sorry.
That's a fair response, and I'll move on.
Yep.
In your rebuttal, Mr. Oliver, you criticize Mr. Fitch's recommendation that the company should regulate financial risks stemming from climate change within the integrated resource plan process, correct?
I'm sorry, could you direct me to the particular part of that rebuttal testimony?
Yes, sir. For the benefit of the commission and opposing counsel, I'm going to be directing the witness to page 8, line 3 of the surrebuttal testimony. Are you there, Mr. Oliver?
Yes, let me clarify the sentence that starts the practical difficulty.
Yes, sir.
Okay. Yes, sir. Should I read that sentence for the?
Yes, sir. Thank you.
Okay. Yes. The practical difficulty with Mr. Fitch's recommendation is that there is not an accepted standard for how to quantify climate-related risk and benefits in economic terms suitable for incorporation and evaluations of traditional versus non-traditional solutions.
But you understand that that's exactly what Mr. Fitch has done in his report. He has taken the time and effort and used accepted modeling software to quantify the economic risks of the company meeting their 2050 goal within the company's base case presented in this proceeding. You understand that's what he's done.
Are you referring to the ETI report?
I'm referring to the ETI report. I'm referring to the exhibits. I'm referring to his 101 pages of direct testimony. Yes, sir.
So my understanding of Mr. Fitch's testimony and the ETI report is that it is not an IRP product. It is not representing in specific detail what other utilities are doing as he lays out as best practice. I would need specific examples to really opine on Mr. Fitch's recommendations. What I found lacking in those recommendations was really specificity about what he would like to see in this IRP or future IRPs.
Okay, you just seemed to make a qualification on my question based on what's in the IRP, but that's not what you say in your surrebuttal testimony. The sentence that you just read does not mention any reference to integrated resource plans. I mean, that's a general criticism of Mr. Fitch, right?
My criticism there was that, from my view, there is no accepted industry standard or regulatory approved methodology for quantifying economic benefits in a way that's suitable for an IRP.
Let's say, for sake of example, that you're correct and there is no accepted standard. Does that mean that someone should not attempt to present a standard to the commission and present what they consider important information to be considered within an integrated resource plan?
I believe, as witness ORS witness Hyatt referenced earlier several days ago, that the IRP processes are continually evolving, and it is important for us to have these discussions about what should be included in IRPs. And I recognize that analysis of climate risk and the implications of those are an area that's under development in the industry. You're probably familiar that we have a settlement agreement with Vote Solar to explore climate risk and resilience issues on the transmission and distribution system. That is intended to follow kind of groundbreaking work that Con Ed did several years ago and follow that approach. So yes, we're willing and interested in exploring these types of things. But my point really in that statement was that at this point in time, there's not an accepted methodology for quantifying those costs in an IRP.
Okay, and I want to bring up something that you just said that's very important. You referenced the settlement agreement between Vote Solar and the companies in the North Carolina Utility Commission proceeding, and you referenced specifically transmission and distribution. You agree, don't you, that settlement agreement, which is very important to both parties, does not at all reference what the company should or should not do in its generation planning, correct?
That's right. This agreement does not address that.
Thank you. I want to talk to you about the model that Mr. Fitch used in developing the ETI report that you've referenced. You agree that it's an analytical model that was based on published and peer-reviewed scholarship from Georgia Tech and Oxford University.
I'm not personally familiar with the ETI report. I did not read it myself.
How do you have familiarity with what Mr. Fitch's arguments are in this case, which you're providing rebuttal testimony to, if you didn't read Mr. Fitch's report?
I was referring to the specific comments in the rebuttal testimony.
Have you read Mr. Fitch's ETI report, Mr. Oliver?
I have not.
Did you say no?
No, I have not. I have not personally read it.
The report that you haven't read, you criticize for lacking a standard, correct?
It was not what my point was in that sentence, again, was that in the utility industry, and as far as I'm aware of other proceedings in the regulatory space, there are not accepted standards for how climate-related costs or risk are factored into IRPs.
All right, well, I want to direct you to, do you have a copy of Mr. Fitch's direct testimony?
Yes.
Okay, I'll now direct you, the commission, and council to page 10, lines 14.
Okay, I think there.
I'm going to get there with you. The question on the table is whether or not you understand what standard Mr. Fitch's report that you didn't review is derived from. And strike this. I'm on a different line here, so this is my mistake, Mr. Oliver. I'm going to ask you, I'm going to strike the question and I'll ask you a different one. Page 10, line 14 of Mr. Fitch's direct testimony discusses that the standard that he uses for the report that you haven't read comes from the Task Force for Climate-Related Financial Disclosures. Isn't that correct?
I'm looking at that sentence and I don't see that, but
okay, maybe might be a citation error. Let me see.
I don't see a citation there.
Okay, let's clarify where we are. I'm on page 10 of Mr. Fitch's direct testimony, and that's on the page that's referenced on the bottom right margin. And beginning at lines 14, if you have it in front of you, would you kindly read the first sentence?
I'm sorry, yes, I was on a different, I was looking at. Okay, so
pagination can be a problem. So let's,
yeah.
If you feel confused, I want to help you out.
Yeah, what page, I'm sorry, what line were you referring to here?
Page 10, referring to the page number displayed on the bottom right footer of Mr. Fitch's testimony, beginning at line 14, if you'd read the first sentence.
Sure. First, a common language exists for discussing climate-related risk. Concern about climate-related risk at all scales led to the International Financial Stability Board to establish a task force for climate-related financial disclosures in 2015 to establish a universal framework and language for identifying, discussing, and ultimately managing climate-related risk.
And you would not dispute, would you, that the Task Force for Climate-Related Financial Disclosures prepared a 114-page report discussing in large part that the standard that you criticize Mr. Fitch for using in the report that you didn't read. Do you dispute that?
So my point is that there is no mandated standard that is a requirement for utilities or public companies at this point in time. I am aware that the SEC is proposing such climate-related disclosures in the future, but there is no current regulatory standard for that's applicable to the utility industry or other industries.
Are you aware of whether or not the Task Force for Climate-Related Financial Disclosures developed a 114-page report that's cited in the footnote here, suggesting exactly what those standards should be?
A suggestion doesn't make a requirement, or it doesn't mean that the utility commissions have supported that.
I'm asking you whether you acknowledge that that report exists.
Yes, I can acknowledge that report exists by the reference here on the page. Thank you.
Thank you.
Mr. Oliver, sir.
Yes, sir. Yes, sir.
For some reason or another, you're going in and out when you answer those questions. I'm not sure if it's a technical issue on our end. Let me check with. Okay, so we're good on our end. I don't know if your voice is fading or you're stepping back from the mic, but for some reason your voice is traveling off.
Okay, thank you for letting me know that, Commissioner or Chair.
Yes, sir. It's still happening. Try testing your mic again.
Okay, mic check.
All right. So wherever you're standing now, whatever your proximity to your microphone at this moment is, if you could keep it there, it would help us.
Okay, I'll try to stay closer. Thank you.
Yes, sir. We are hearing you loud and clear now. So if you could stay where you are. Thank you, sir.
Yes.
If you didn't read the report, you probably can't tell me whether or not Mr. Fitch, in developing that report, used the standard established in that 114-page report from the Task Force for Climate-Related Financial Disclosures, can you?
No.
Okay. Do you have familiarity with the content of the 2050 climate report and the standard that it used?
The Duke Energy 2050, I'm sorry, are you talking about the 2020 climate report or something else?
Thank you for asking for that clarification. I appreciate that. So I'll rephrase the question. I think that it's going to be better for you to answer. Are you aware of the standard and framework that Duke Energy used in developing its 2020 climate report?
Yes, in terms of our objective to demonstrate illustrative pathways to reach net zero by 2050. I'm familiar with that.
Would it surprise you to learn that Mr. Fitch used the exact same standard that's present and that the companies used to develop their 2020 climate report?
I was involved with the modeling, but in review of the report, but not directly involved with the policy part of that report. So I should qualify my answers as I am not a policy expert.
Okay, I'm going to refer the witness commission and counsel to page 3 of hearing exhibit 5, and I'll pull it up. Mr. Oliver, are you able to see my screen? I'm going to need to blow this up.
I can see that.
Okay. Footnote 1. If I'm going to read this to you, if you're having a hard time reading it, I can blow it up again. Just want to
I can read it. Thank you.
Okay. Please read footnote 1 for the commission.
This report, like our 2017 climate report to shareholders, is aligned with the disclosures recommended by the Task Force on Climate-Related Financial Disclosures, TCFD.
So the companies use the Task Force on Climate-Related Financial Disclosures, that standard, to develop their 2020 climate report, but you criticize Mr. Fitch for using the exact same standard in developing the ETI report that you did not read, correct?
Mr. Chairman, I'll object to the form of this question. Mr. Oliver has already provided testimony that he did not criticize Mr. Fitch's report. He just had a different view. I believe that's in the record already, so I'll object to the form.
Okay, Attorney Spear.
Cross-examination.
Okay. I mean, I understand what you're doing, but are you not asking the same question again in a different form?
Well, I think that the objection went to the characterization of Mr. Oliver's testimony as whether or not it was a criticism of the report. And I can read that testimony now. The practical difficulty with Mr. Fitch's recommendation is that there is not an accepted standard for how to quantify climate-related risks and benefits in economic terms suitable for incorporation and evaluations of traditional versus non-traditional solutions. That's a criticism. And what I'm trying to establish, as the commission likely already knows, is that part of this issue is what standard was used. Mr. Fitch used the standard in his report that is the exact same standard that's referenced in the 2020 climate report. I'm establishing an inconsistency in Mr. Oliver's position. I believe it's relevant, completely appropriate for cross. And if the companies or Mr. Walburn would like to address it on redirect, they're happy to do it. That's my position.
Attorney Wilburn?
Yes, sir. Mr. Chairman, my view is that Mr. Oliver, and not in his pre-file testimony, but in testimony he just provided at the beginning of this line of questions, disagreed with counsel's representation that Mr. Oliver had provided, had criticized what had been issued and prepared by Mr. Fitch. And it's just the form of the question in light of the testimony provided by Mr. Oliver that I have a problem with.
Okay. Now I'm going to overrule your objection. Please proceed.
Mr. Oliver, Mr.
Can you repeat the question, Mr. Spear? Sorry for talking over you.
And I don't want to talk over you. Mr. Oliver, do you acknowledge that Mr. Fitch uses the same standard that you criticize as the same standard that the companies used to develop its 2020 climate report?
I acknowledge that Mr. Fitch referenced the TCFD guidelines, and I acknowledge that that is in the 2020 climate report. What I'd like to differentiate is that the practices that are used in an IRP are least cost planning, and we apply, technology cost to determine what the least cost plan are. In the 2020 IRPs, we illustrate various pathways to represent potential policy outcomes, recognizing that we have an uncertain view of what future policy may be. So we wanted to represent those potential pathways in the IRP. I would say that what was in the 2020 climate report was an illustrative pathway. It was not an IRP per se, and there are elements in that 2020 climate report that are not relevant to an IRP. And again, I'm not a policy expert, so I'm not familiar with the specific application of the TCFD in the 2020 climate report.
Are you suggesting to the commission that Act 62 standard for their discretion in this proceeding is least cost planning, Mr. Oliver?
No, I'm suggesting that what the fundamental principle for IRP planning is least cost planning. And again, we have uncertain policy at the federal level that could definitely influence the pathway to net zero carbon by 2050.
I want to clarify your testimony that a fundamental element of the company's integrated resource planning in this proceeding was least cost planning.
Least cost planning is a principle of IRP planning. I would be surprised if any of the other expert witnesses dispute that.
What other?
May I expand a little?
Yes, sir. Yes, sir.
Thank you. So least cost planning is always within the framework of constraints. And so regulatory mandates are a constraint. And if there are regulatory requirements, then that becomes, planning within that framework becomes the least cost plan under those requirements. So that's what I'm saying is that least cost planning is a fundamental precept of integrated resource planning.
the Vice President of Integrated Systems Planning, correct, for the companies?
That's correct.
Are you able to inform the commission of what other considerations are contained within Act 62 that the commission and the company should consider for its resource planning?
I am not an expert on Act 62. I would defer these questions to Witness Snyder.
I'm going to show you a portion of the IRP here shortly, if you'll give me a moment. Well, in light of time, would you dispute that page 8 of the Integrated Resource Plan, the executive summary that was prepared and attached to Mr. Snyder's testimony, says that, quote, all pathways included in the 2020 IRP keep Duke Energy on a trajectory to meet its carbon goals over the 15-year planning horizon?
Yes, I accept that.
Thank you. What analysis did the companies perform to make such a claim?
It was based on the observation that all these pathways reach at least the 2030 goal of 50% carbon reduction.
What specific analyses did the companies perform to confirm that?
It was embedded in the IRP modeling analysis that the carbon reduction results were very clear there in the executive summary.
In what way? How is it embedded?
If we look at the table that shows the combined system portfolio results, I believe that's on page 16 of the IRP for the DEC executive summary. That shows greater than 50% carbon reduction at 2030 for all the 6 portfolios.
Sure, and I appreciate that, but you're giving me outputs. I want to understand what the company did to determine whether or not that statement is true. What analyses were performed? I believe that your testimony is that it was embedded. What does that mean and how was it embedded? And please tell the commission how that is an analysis.
The analysis is a review of the results.
What studies did the commission, or excuse me, did the companies perform to make sure that its results were accurate?
There were a lot of reviews of the results, as would be normal for any IRP process prior to publication and filing.
What sensitivity analysis was done on the integrated resource plans proposed in this proceeding to make such a claim that it keeps the companies on trajectory to meet the 2030 goal?
There were numerous sensitivities in the IRP. I would defer the specific discussion of that to Witness Snyder.
Is the answer that you don't know?
I know that there were sensitivities around technology costs, load forecast, fuel price forecast, and other.
Point of question, did the companies at any time take an inventory of their greenhouse gas emissions that would have been produced by, let's say, the base case and compare it to their carbon goals of either 2030 or 2050?
As I said, the results on the executive summary page illustrate that the carbon reductions are exceeding 50% by 2030 in each portfolio.
What analysis did the companies perform to achieve that result?
All the modeling that went into the IRP produced that result.
There's no analysis beyond 2030, correct?
The IRP to 2035.
Say that again.
The filed IRP includes results out to 2035.
Okay.
Modeling does extend beyond that, but as far as the results that are published in the IRP, it goes through 2035.
Thank you. I'm going to refer the witness what has been marked as Vote Solar Cross Exhibit 14, and this was delivered to the commission and the parties this morning. And I'm going to share my screen now. Mr. Oliver, are you able to see my screen?
It's a little small, but I can see it.
Okay, I'll pull it up.
That's more than enough. Thank you.
Thank you. All right, do you have any familiarity with the company's responses to Vote Solar's discovery requests?
Some.
Okay. Can you identify this one as the company's response to Vote Solar data request number 2?
Yes.
Okay, thank you for that. Mr. Chairman, I move Vote Solar Cross Exhibit 14 into the record.
Vote Solar Cross Exhibit 14 will be marked and entered into the record as hearing Exhibit 38.
Mr. Oliver, are you able to read the request and the response as it appears on the screen?
I am.
Okay.
I'm sorry, go ahead.
This goes to the same question that I was asking, and I'm really curious about the company's analysis of whether or not it's able to meet its 2030 goal, or as the IRPs lay it out on path to a 2035 trajectory. I'm going to read this request to you, and then I'll ask you a question. This refers to the IRP report that we discussed, and it says, all pathways included in the 2020 IRP keep Duke Energy on trajectory to meet its carbon goals over the 15-year planning horizon. And here's the question. Has Duke Energy conducted analysis or applied any criteria to determine whether the 2020 IRP pathways keep Duke Energy on a trajectory to meet its carbon goals? Given that question, I ask you to read the response and tell me whether or not the companies stand by that response.
Mr. Chairman, I hate to interrupt again, but I object again to the form of the question. He asked whether the companies stand by the response. Mr. Oliver is providing his own testimony this morning. So again, I would object to the form of that.
Somebody's got to speak on behalf of the company. I mean.
Overruled.
Thank you.
Okay. I'll read now the response if that's your request, Mr. Spears.
Sure, it is. And if you want to add any clarification or edit or addition, I invite you to do that.
Okay. As stated on page 8, Duke Energy.
I don't think we probably don't need to bother the court reporter in that sense. I was just sort of asking maybe to read it too.
Okay, thank you. So yes, I have read this and stand by it.
Thank you. Does Duke take a position that it should never consider the economic risks of climate change in its resource planning?
Can you clarify specifically which economic risk you're referring to? I think there's a question of what's relevant for an IRP. I would like to have clarification on that, please.
Well, let's take, for example, the ETI report. I'll represent to you that the report that you haven't read, it focuses on stranded assets associated with gas build out of the company that's not consistent with its 2050 goal. So does the company take the position in its IRP that that those risks should never be considered?
No, in fact, the company did perform, and again, I'm not the most familiar with this witness matter, would be better to speak to it, but I am aware that the company performed a sensitivity around a reduced service life for natural gas assets, and reduced that by roughly 30%, and the model still selected those as economic resources, even if they had a shortened life in that situation. I would add too, though, that there are possibilities of technological developments that enable those assets to continue operating at reduced or zero carbon in the future, such as hydrogen or carbon capture sequestration technologies.
Did you consider the costs of those technologies in the integrated resource planning?
We do consider those options to the extent that that information is available. At this time, hydrogen costs to produce are very uncertain. There is a lot of emphasis, as you're probably aware, on advancing that in the new administration. So, we're aware of that potential, but the reason we didn't specifically take credit for converting to hydrogen was because of uncertainties in how the timing of that would materialize and to what extent the cost would be improved over time through technological advancements. And similarly with carbon capture sequestration technologies or utilization of carbon.
We've heard a lot about what the companies are doing and not doing to interconnect new renewables. Is it your opinion that the companies are progressive on integration of renewables into their fleet?
I believe so, and I believe that's reflected in the work that we've done with stakeholders around interconnection queue reform to reduce the cost and introduce some efficiencies in terms of how projects are studied. And so I think that benefits the interconnecting customers as well as the company and the general benefit there. I would say, in addition to that, we have, by the evidence of how much solar we have on the system that I read earlier in my testimony, it's an indication that the company has worked diligently with interconnecting customers to allow that to proceed expeditiously. So North and South Carolina have a significant level of renewable penetration, and that would not have happened without support from the company.
And those facts speak for themselves, but the point that I'm trying to get at here is whether or not the companies are or are not progressive on integration of new renewables. That does not mean that they have achieved the standard of a reasonable and prudent IRP, correct?
I do believe we're progressive, and I think that's reflected in the carbon goals. The company is not disputing the need for renewables to achieve those carbon goals. We certainly see a vital role for renewables, storage, and other technologies to achieve those aggressive carbon reduction goals.
I'd ask for a yes or no to this question. If a utility is progressive on renewables, it can also fail to meet the reasonable and prudent standard under its IRP, correct? That's just a simple yes.
I'm sorry, repeat the question, please.
Just go ahead and answer the question any way you see fit.
I'm sorry, could you repeat the question? I didn't catch all of it.
I'll withdraw the question and conclude Vote Solar's cross-examination. Thank you, Mr. Chairman.
Office of Regulatory Staff.
ORS has no questions for this witness. Thank you, Mr. Chairman.
Commissioner questions?
Mr. Chairman.
Commissioner Powers?
Thank you, Mr. Chairman. And Mr. Oliver, thank you for your testimony. But I caught in there somewhere when you were being questioned by Mr. Spear that a lot of the criticism on Mr. Fitch's report, but you haven't read the report. Is that what you testified to?
The ETI report specifically, and I believe there are other witnesses that are better suited to, that have reviewed that report in detail.
Okay, well,
yes.
What can be frustrating for us sitting here, and it seems that company witnesses are doing this, if you know the answer to a question or whatever you do know, answer it rather than defer to another witness. I noticed that on several questions that you defer to another witness, but yet some of them I believe you can answer. It makes it hard for us when we're trying to keep a steady flow of this to have questions deflected or deferred to other witnesses. Another thing that kind of popped out to me, you talked about uncertainty on the federal level. I think Chairman Glick has been fairly clear and even vocal this month that there needs to be substantial DERs. That should be part of any plan. Eliminate barriers to DER. And I don't know that they're going to have to, but I think what the FERC's pretty much saying is that if the companies will work with regional shareholders, then there won't be standards set, but if not, there would be standards set as far as putting values on different things, particularly values as to the risk involved as far as determinations that you say, I think in your testimony, you said the company could not quantify cost as to climate transition. So there's not really that much uncertainty on the federal level, is there? I mean, your company keeps up with what FERC says or does or is headed toward. Is that correct?
We do. May I expand on my answer?
Yes.
Okay, thank you, sir. So when I referred to uncertainty, I was really referring to primary drivers of carbon reduction, such as carbon price or clean energy standard type programs that would have a direct impact in resource selection. Of course, tax incentives are also a mechanism for that. And when I referenced uncertainty, I was really referring to potential policy outcomes at the federal level, as well as potential legislation here in the Carolinas that might drive additional renewable adoption.
Okay, and I think we all, like it or not, can see how things are heading as far as on the federal level, and of course, until there is legislation, I don't see how you can really put some things in the IRP. But one thing between you and Mr. Fitch, I think he talked about you did not agree with deferring things such as enhanced transmission investments or generation distribution investments. Is that correct?
That's correct.
And I think within things like enhanced transmission, I don't see why there's a difference. It seems to me that enhanced transmission and upgrade of systems is a benefit both to solar and otherwise. Is it not?
I would agree with that.
And I guess some of that is, pay me now or pay me later to do those things.
I would agree with that. Thank you.
And you have that in your plan as far as these costs. Is that correct?
I'm sorry, are you referring to grid investment costs?
The IRP, the investments that are going to be necessary in order to reach these goals.
That's correct. There was an estimate, a high-level estimate of various grid investments needed to enable different levels of renewable adoption.
Well, I would encourage and hope the company would really look at putting values, quantifying values on climate risk, rather than us having to wait for the federals to give us those standards. If that can be worked out between your company and the stakeholders, do you not think that would be in the best interest of us locally?
Yes, I appreciate that comment and certainly support that for things that are relevant to the IRP. The difficulty that I had with the recommendation of Mr. Fitch was really the lack of specificity of things that are relevant to the IRP. It seemed to be very encompassing, and we're certainly happy to talk to stakeholders about climate-related costs that are relevant for an IRP.
Well, and one of the hard things that we have to balance is, you know, with things happening and they're happening fast, is that, you know, you got shared responsibilities, you got shared costs, and I think where those costs go, whether they go to the rate holders or the company or to it looks like we're getting them ready to just print money for different things. Assigning those costs is a very difficult thing, and I appreciate your work in that area. Thank you.
Thank you, Commissioner.
Mr. Chairman, Taylor Spear, Vote Solar.
Yes.
I don't see how I can't make a motion to strike Mr. Oliver's criticisms of Mr. Fitch's report specifically on grounds of lack of foundation and complete speculation if he's never bothered to read the report. I don't take pride in doing this. I'm not particularly excited about making this motion, but I've got to protect my client. And I had an opportunity to speak to him after the testimony, after I learned what Mr. Oliver's opinion is based on, and I'm just really surprised, and we moved to strike the criticism on that ground.
When you say criticism, Attorney Spear, are you referencing that sentence?
I'm referencing, well, I don't think that the companies would deny, and I don't think that the Mr. Oliver would deny, that his purpose in this proceeding is partly to rebut Mr. Fitch's testimony. How can he do that in any way, shape, or form without the foundation of having read the 75-page report?
Mr. Chairman, I'll wait for your clearance to respond.
Well, let me just establish what Attorney Spear is trying to do. So it sounds like you want to strike his testimony in its entirety. Is that what you're asking?
Strictly as to Mr. Fitch, yes. There's a lot of stuff there that doesn't apply to us, but how can you come into an evidentiary proceeding with the intent of rebutting months' work of my client's work and not have read the work?
I understand what you're saying. Could you help me out and tell me maybe pages, lines?
I think this might be a solution, and would ask for a leave to brief the issue, because I agree with Mr. Chairman, what you're trying to achieve as well. How do we parse this out and what's what? And I think that could be better done with a little heavier legal analysis after having reviewed it. So I would ask for permission to brief that issue and be heard on it at a later time.
All right.
Attorney Wilburn. Mr. Chairman, at some point, I'd like to ask Mr. Spear a question.
Yes, sir. Let me hear from Attorney Wilburn, and we'll get to you.
All right.
Thank you, Mr. Chairman. Mr. Oliver's testimony was filed on March 19th, 2021. His testimony is explicit about responding to Mr. Fitch's testimony in very specific ways. If counsel for another party had a motion to strike at some point, they should have considered filing it at least 10 days ahead of the hearing pursuant to the commission's rules. I have no inherent objection to briefing this issue, but I don't see it as being warranted of really any meaningful consideration by the commission. And
I'd respond to that. I certainly wasn't expecting Mr. Oliver to say that he had not read the report until today.
Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Spears, does your concern, it really addresses the appropriate weight and credibility that the fact finder should give the testimony? Wouldn't you agree?
Absolutely. That's certainly one angle that the commission could take on this. Yes, sir.
And so wouldn't it be better just to leave it in, because it may actually weigh out in your favor to leave it in?
That was, I don't want to reveal attorney-client privilege, but you know, the risk and rewards were discussed with the client, but I can certainly continue to consult with the client and determine maybe a different course on this. But you certainly raise a very good point and something that I've considered.
Thank you, sir.
Yes, sir.
Thank you, Mr. Chairman.
Attorney Spear, I'll leave it up to you whether or not you want to continue with your client or get a ruling on your motion. But I have commissioners with questions, so what do you want to do?
May we just defer this particular issue until, you know, maybe commissioner questions are complete?
Sure. Commissioner Caston.
All the hubbub, I may have forgotten my questions, but I don't think so. Let's see. Mr. Oliver, good morning,
Yes,
by
sir.
the way.
Good morning.
You are the Vice President of Integrated System Planning.
That is correct.
And it's,
I'm sorry, go ahead.
And it says in your testimony that you lead the Integrated System Planning Group, which includes the IRP and the ISOP. Is that correct?
That's correct.
Now, by leading, and I can say this firsthand, that I didn't know all the details or everything that was going on with the stuff that I supposedly led. Is it a fair assessment to say that, well, let me ask it this way. As Vice President of Integrated System Planning, and you lead Integrated System Planning, IRP and the ISOP, that at least at a fundamental level, you have or should have a basic understanding of knowledge of what's going on. Is that correct?
That's correct.
The portion of the report, you say, in response to the question, what is the purpose of your rebuttal testimony in this proceeding? You say, my rebuttal testimony responds to certain assertions and recommendations made by Vote Solar witness Tyler Finch related to the ISOP. Did you read or study at least whatever that section is?
Yes, that section of his testimony, that was specifically what I was asked to comment on, was the assertions related to ISOP.
Okay, so you're saying you read that portion of his testimony. Did you read that portion of his study related to the ISOP?
I did not really read the ETI report related to ISOP. I didn't understand that there was a reference to ISOP in that report.
Well, whether there is or is not, I guess, did you read any portions of the study?
No, I may have glanced over it in some weeks past, but did not dig into that. I was aware that other witnesses had reviewed the report and would defer to them on any particular questions about it.
And I absolutely understand all the stuff you got to keep up with. I mean, I suspect it's a lot.
It is.
That said, I can't imagine coming in to testify about something that I don't have some basis. I don't always know what I'm talking about, but I try to understand what I'm talking about or figure it out. And I am not implying at all that you do not know what you're talking about. But do you think it prudent to study, read, be prepared for what you're getting ready to give testimony about?
Yes. Yes, I would acknowledge that that should have been done.
And if I understood Mr. Back's testimony previously, something he said has maybe nothing to do with any of this stuff, but it sounds like he was talking about something Duke Energy does as a whole that sound a lot to me like continuous improvement, a culture of continuous improvement, plan, do, act, check, something like this. Duke have something like that?
I believe I did hear something to that effect with regard to ongoing program development. Yes.
If Duke has that and they operate that way, you would either know that or not know that because it's a culture thing.
I do, yes.
And I have absolutely no reason to believe otherwise that Duke does not do that or does not believe that. I'm personally a strong advocate of such. That said, do you agree that for continuous improvement to be the best you can be as a utility or anything else, do you agree this occurs when information and feedback is accurately assessed?
Yes.
I mean, the only way to improve, in my opinion, is to ask the right questions, get the feedback. Some answers you like, some you don't, but you got to know the truth before you can move forward. Would you agree with that?
Yes, I agree.
All that said, I understand you have a lot on you, and I suspect everybody does. And I suspect this has not been particularly pleasant. Is that true?
That's true.
Well, I believe a path forward for Duke and all the utilities, hopefully that take serious continuous improvement, doing the right thing the right way all the time, is let's ask the right questions, get the right answers, and move forward. And to your credit, I appreciate you answering honestly because I know this has been uncomfortable, but I do appreciate that.
Thank you, sir.
No more questions.
Any more commissioner questions for this witness? All right, hearing none, redirect.
I have suddenly some limited redirect, Mr. Chairman.
Yes, sir.
Thank you. Mr. Oliver, do you recall how many pages of pre-filed direct testimony Mr. Fitch filed? Was it in the ballpark of 100 pages?
Yes, something like that. I think 190 or something. Are you talking about with exhibits or?
Just the testimony itself.
Okay.
And I can pull it
Yes,
up.
yes, yeah. Oh, I'm sorry. Yes, 100. Yes.
And was the ETI report related to carbon stranding part of the scope of your rebuttal testimony?
No, it was not.
Are there other witnesses that the companies are presenting and who will appear during this proceeding whose testimony addresses the ETI report?
Yes. Yes.
And for benefit of council and the commission, I'm quickly going to share page 5 of Mr. Oliver's pre-filed rebuttal testimony, if I can. Mr. Oliver, what was the nature and scope of your rebuttal testimony?
It was specifically to respond to comments related to ISOP, Mr. Fitch.
Thank you. Thank you, Mr. Chairman. That is all the redirect that I have.
All right. Attorney Spear, have you decided whether or not you wanted to proceed with your motion or move on? Or do you need more time?
Taylor Spear votes solar. There will be no motion.
All right. Is there anything else for this witness?
No, Mr. Chairman.
All right. You may step down from the witness stand, sir.
Thank you, Chair.
All right. I think it's a good time for a break. Let's come back at 12:05.